found it interesting. Earlier in my career, there were times when I was responsible under ethics or professional responsibility or deontology rules of multiple jurisdictions, and of course there are similarities. And there are times when you're trying to be compliant and stay out of trouble under the rules of many of them. And your basic principle is you're trying to maintain client confidences. And that's a general rule for lawyers just about everywhere. But keeping in mind that it's not just that as a lawyer you're trying to maintain client secrets and keep them from harm, so that they have the opportunity to plan and if they're a company to make their market strategies and keep their trade secrets and develop their plans and keep them free from interference by competitors and potentially from thieves and hackers and be able to keep their confidences, but that those rules are to some degree and very different degrees from one country to another, paralleled by rules of evidence and civil procedure and criminal procedure, and that the way those rules play out is quite different from one jurisdiction to another, and that there's quite a gulf between the countries with a common law tradition and the countries with a civil law tradition, and that as you're dealing with multiple jurisdictions and even in individual transactions, but certainly when there's a risk of litigation or regulatory enforcement, for example, you need to make your client, whoever that is, aware of what those differences might entail. And that means being very sensitive to what your position is within a larger group. If you're working for the Australian affiliate of a company that, in a group that might be where the decision makers might be in Japan, for example, the expectations of senior management are going to be very different than if it's part of a group where decision makers might be located in New York or in London or in Delhi. And if you're part of a Chinese group, that's going to be very different indeed. So a good deal of the challenge for the corporate counsel is understanding what the expectations of management are going to be, and you may be in a position of having to educate them about how the advice that you're giving as corporate counsel and that they're getting from outside counsel needs to be handled in order to maintain confidences. And there's often a trade-off in the jurisdictions that have the broader discovery rules, with the U.S. being the extreme example of that, with very broad discovery. Then there's going to be more of an emphasis on broad privilege rules, as opposed to the jurisdictions in civil law countries, for example, where there's very limited discovery and there's less emphasis on privilege. And what the common law lawyer needs to realize is that our training tends to be thinking in terms of privilege as the client's right, something that's designed to protect client confidences and encourage, in the interests of the administration of justice, encourage clients to be able to speak candidly and early with their legal counsel. In order to for legal counsel to be able to advise them fully about legal consequences, and in the interest of getting matters before, in the litigation context, before courts, and in the interest of compliance and getting clients well informed about what are sometimes complicated and not always obvious legal and regulatory regimes. Whereas in civil law countries, it's not really the same perspective at all. Lawyers have an obligation to maintain professional secrets, but the client's rights really come up in the context of a right of defense, which is really only triggered in adversarial proceedings where there are penal consequences or serious administrative sanctions. And so that means that when you're working as corporate counsel in-house in a company, for example, you make a strong distinction between when you're giving business advice and when you're giving legal advice. And when you're giving legal advice, if you're worried about maintaining confidentiality, you focus on making sure that you're noting when there are penal or criminal sanctions, or when there's a possibility of litigation, because you're much more likely to be able to maintain confidences that way. And you're recognizing that big distinction between common law countries and civil law countries, where outside of the countries with the common law traditions, just the fact that you're a licensed member of the bar, once you're working in-house in a company, in most countries, you're not going to have the equivalent of a legal privilege that's protecting what you do. In some cases, for example, in Germany, there are civil and criminal procedure rules that will protect some of your activities and your advice as a licensed lawyer, but in most countries there won't be any such protection, and that means that that you are more likely to need to turn to outside counsel if you want to have certain kinds of advice and document gathering and witness interview gathering afforded any kind of protection. When you're dealing as corporate counsel with a transnational matter, or especially when it looks like it may become contentious, that you consider using outside counsel in a jurisdiction with strong privilege, and gathering the documents and data in that jurisdiction, and using outside counsel and outside experts, forensic accounting experts, IT experts, under their supervision in typically a common law jurisdiction that is going to enjoy more privilege, and recognizing that the courts deciding those issues for evidence purposes and civil and criminal procedure purposes are, when it's multi-jurisdictional, are going to look at not only at where the communications happen, because in today's world the communications are going to end up touching lots of jurisdictions, but they're going to typically end up looking at where the actual lawyering was performed, and applying principles of comity. And a good example of that in fairly recent history was in the litigation, which was mostly centered in the state of New York in the U.S. over the Bernie Madoff Ponzi scheme, where individuals in many jurisdictions around the world were defrauded. And the Citco company was relying heavily on advice from senior Dutch counsel who was licensed who was also an employee of the company, and was located in the Netherlands. And as in many civil law jurisdictions, as a result of him being an employee of the company, he was not treated under Dutch law and ethics rules as having independence, and therefore not getting the benefit of professional secrecy, and what common law lawyers would think of as professional legal privilege, and therefore the communications that went through his office and concerned the advice to the company concerning the litigation that was happening in New York, where there would have been privilege for the lawyers involved, it was treated as waiving the privilege, and all of those communications had to be produced in discovery in the civil litigation in New York. So the federal court in the U.S. applying principles of comity ended up disclosing requiring disclosure of all of those otherwise privileged communications. And that's actually a fairly typical result that you'll see in not just in U.S. courts, but in courts around the world. So it does matter where the documents end up being gathered up and where the lawyers are actually operating. Another good example is looking at the Panama Papers scandals, because you ended up with the Panama law firm Mossack Fonseca, and after the leaked documents showing how shell corporations and trusts were set up by their affiliated law firms, including the New Zealand law firm, how that was being done around the world, there was enough evidence that there were frauds being committed and fiduciaries that were not acting in accordance with their fiduciary duties, that you had the civil authorities and police in several jurisdictions that just made raids on lawyers' offices. And that tended to happen more readily in civil law countries than it did in the common law countries like the United States and New Zealand. But in countries like Peru and Panama, El Salvador, Switzerland, they more readily breached their professional secrecy.